Thank you, Judge Sykes. If Lino ever retires, I want to be the contrarian-in-chief when he's done with the title. Today on this panel, my role is going to be, my self-appointed role is going to be explaining the interpretation and construction distinction and why it's necessary for everyone, including originalists, to acknowledge it, and not to defend any particular approach to constitutional construction, but only to, in some sense, defend the idea that everyone does it, and it's inevitable, unavoidable, and however you choose to do it, you need to defend how it is you're doing it. So let me begin by defining what I mean by interpretation and construction. Both interpretation and construction are activities. Interpretation is the activity of identifying the semantic meaning of a particular use of language in context. Construction concerns the application of that meaning to particular factual circumstances. Originalists may disagree about many things. You heard about some of the things that originalists, from Professor Fallon, what originalists may disagree about, though not quite so many as you might imagine, including originalists may very well disagree about how you should do construction. But I believe all of us who are originalists should agree on the meaningfulness of the distinction. For without it, we are very likely to be talking past each other or our critics and confusing ourselves and others. Now, what defines originalism is the belief that the semantic meaning of the written Constitution is fixed at the time of its enactment, and, assuming the Constitution is legitimate, should remain the same. The meaning of the semantic meaning should remain the same until properly changed by written amendment. This, I believe, no matter all the differences that Professor Fallon pointed out last night amongst originalists, I think this is the core of originalism that all originalists share. It is what makes all those theories within the same family of theories called originalism, notwithstanding whatever differences they may have. The original meaning of the text provides the law that governs those who govern us and those who are bound by the Constitution, whether judges or legislators, cannot properly change its meaning without going through the amendment process. This is what originalists, I think, are committed to. Where the semantic meaning of the text provides enough information to resolve a particular issue, then in application it will require little, if any, supplementation, and construction will look indistinguishable in practice from interpretation, although it's always there. That each state is entitled to 2 senators requires little construction to apply. But however much information is contained in the text of the Constitution, there is not always enough information to resolve a particular issue. To see why this is so, we must understand how language can be either ambiguous or vague. Consider the example of a light feather. The term light can be both ambiguous and it could be vague. A feather could be said to be light in 2 senses, and therefore ambiguous. A word that has more than one sense is ambiguous. Light could refer to the weight of the feather, or to its color or shading. When I say that this feather is light, most likely I mean one of these senses or the other, but probably not both at the same time, and unless I'm being poetic or clever. The context usually reveals which sense is meant. The term arms in the Second Amendment could be referring to weapons, or it could be referring to the limbs to which our hands are attached. Context reveals it refers to weapons. But even when context reveals which sense of light or arms is the intended meaning, there is still a problem of vagueness. Just how heavy must an object be before we cease calling it light and start calling it heavy? Just how tall must a person be before he or she is no longer short? The problem of ambiguity, more than one sense of a word, can usually, though not always, be resolved by interpretive methods. And even when we are not entirely certain of which of 2 competing senses or 3 competing senses was the intended one, when there are multiple senses of a word or phrase, historical evidence almost always establishes one meaning as more probable than the others. Special problems of ambiguity can arise when the evidence of meaning is lost or non-existent, or when drafters deliberately injected ambiguity into the text by using, for example, euphemisms, as they did when they referred to slavery, but they did not call slavery by its name. Instead, they chose words that ordinarily had a very innocent meaning, like, for example, persons, to refer to slaves. So now you have the deliberate injection into a document of ambiguity. What did persons mean? For example. Now, these exceptions, they're relatively unusual exceptions aside, evidence of original public meaning, in my view, generally resolves questions of ambiguity. By contrast with vague provisions, the term itself, even when interpreted contextually, simply does not contain the information necessary to decide matters of application. What is a reasonable search? And for that matter, what exactly is a search? Is the thermal imaging of a house to detect increased heat caused by marijuana cultivation growing in the basement a search? Vague terms are not wholly indeterminate. They do have meaning, but they are underdeterminate. Clear cases of items that are light or heavy, that's a search or not a search, do exist. The terms have, those terms do have meaning, but the problem is the application of original meaning in borderline cases that are neither clearly in nor clearly out. Now, when this happens, we must engage in construction. Our restrictions on sound trucks on residential streets an infringement on the freedom of speech? Well, it certainly seems like they could be. How about the requirement of obtaining a parade permit before demonstrating on the public streets? An infringement of the freedom of assembly? Perhaps. The original meaning of the text simply doesn't definitively answer these and many, many other similar questions. Instead, we handle these questions by the doctrines, in this case in the freedom of speech area, governing time, place, and manner regulations of speech, press, and assembly. These doctrines are constitutional constructions that are nowhere in the text and should not be dismissed simply because they're not in the text, because they are necessary to put what is in the text into action. Now, this is not to say that when the information provided by interpretation has run out, all decision rules have run out. We could adopt a decision rule, for example, that when a term is vague, it's given its narrowest sense, say. Or in the constitutional case, we could say that whenever a text is vague, legislatures have a free choice in borderline cases and cannot be second-guessed by judges. That's a decision rule we could adopt. Actually, I think Lino would adopt the rule that even when the test is not vague, the decision rule should be that judges should not be able to second-guess the legislature. That's a perfectly acceptable rule of decision. It's a decision how to decide a case. But these decision rules are rules of construction. They are not rules of interpretation. They are rules that apply when the meaning that is there is insufficient to decide an issue. But the issue must somehow be decided by someone. Even if it's the decision to defer, that's itself a decision. Now, according to this distinction between interpretation and construction, originalism is a method of constitutional interpretation that identifies the meaning of the text as its public meaning at the time of its enactment. That's what makes originalists originalists. Now, this Constitution may say a lot. Let me hold up a copy of this Constitution. This Constitution may say a lot, although this particular document also contains the Declaration of Independence, which says somewhat more. But whatever information is contained in here, originalists think you should respect and follow the original meaning of the information that's contained in this document. But whatever information is contained in this document, it doesn't have all the information you need to decide particular cases in controversy. The information in here runs out at some point. And originalism is just not a theory about what to do when original meaning runs out. Now, this is not a bug. I believe it's a feature. Were a Constitution too specific, such that its original meaning would resolve lots more cases, it would probably become out of date very quickly. A Constitution with some vagueness delegates some decisions or applications or exercises of judgment to future actors, whether they be in the judiciary or in the legislature, provided that they do not violate the information that is contained in this document. Originalists will not all agree about how to do constitutional construction. Just as originalists, however, need a normative theory as to explain why we today should adhere to the original meaning of the Constitution, we need a theory about that. One also needs a normative theory for how to construe a Constitution when its meaning runs out. I just think there is no escaping this. If you think the court should defer to the legislature when a particular clause is vague, you need a normative argument for this principle. Because this principle is not in the Constitution itself, original meaning will not supply the argument. The same goes for adopting a presumption of liberty, as I have, that places the burden on the government to justify its restrictions on liberty as necessary and proper. You need an argument on behalf of that, a principle of construction. Now, with this as background, let me briefly turn to what Professors Mike Rappaport and John McInnes have called original methods originalism. Now, there is much in, and some of you may have heard about this, and that's why I'm addressing it. Now, there is much in their method that I agree with, and their articles. First, we agree that the meaning of constitutional language should be ascertained by interpretive methods that were in existence at the time the language was enacted. We agree about that. Secondly, we agree that most senses or cases of ambiguity can be resolved in this way. We agree about that. But where I think we disagree, in good faith, is about the problem of vague language. Whereas I think they treat, in their work, in their articles at least, ambiguity and vagueness as essentially the same problem, where we have to assign the most probable meaning. I believe these are actually two distinguishable linguistic problems. With vagueness, meaning truly does run out after all genuinely interpretive methods are exhausted. More historical evidence will not tell you whether the thermal imaging of a house is or is not a search. Of course, some supposedly vague provisions in the text are, when originalist methodology is properly applied, often much less vague than they are made out to be. But residual vagueness inevitably remains and is only concealed by treating rules of construction like deferred legislatures in case of vagueness as though they were rules of interpretation, which they are not. Further, when we examine the original methods used at the founding, we discover that while we typically start with text and then recur to first principles when meaning runs out, in the earliest and greatest constitutional cases, the early Supreme Court typically appealed first to first principles and only then to text. Just reread, in light of that, just reread the cases like Chisholm versus Georgia, Calder versus Bull, Fletcher versus Peck, Marbury versus Madison, McCulloch versus Maryland, and see for yourself. While no one then contended that first principles could ever trump the meaning of the text, no one ever suggested that, they did think these first principles could be applied by courts to fill gaps in the text. In fact, they thought first principles came first. Now, if I am right as an empirical matter, that construction is inevitable because original meaning runs out at some point, then originalists need to debate not only the appropriate approach to constitutional interpretation, but also the appropriate approach to construction. Much as some might wish to avoid this discussion, I believe we only confuse ourselves and our audience if we try to make more of interpretation than the text will bear by collapsing the distinction between these two necessary but distinct activities. Thanks.